Good afternoon. This presentation focuses on the changes that are in the 2012 discipline regarding security of appointment, transitional leave, and less than full-time appointment for elders. The disciplinary references I will make in this presentation are from the 2012 Book of Discipline. A draft copy of the 2012 discipline as related to District Committee and Board of Ordained Ministry work is available on the GBHEM website at gbhem.org/BOM for your reference. Look under the first green bar and the link there will allow you to download the document. Many changes have become a part of the 2012 discipline in these three areas. While we won't know the final outcome of security of appointment until after the Judicial Council meets in October, the changes regarding transitional leave and less than full-time appointment are changes that boards will need to be aware of. My name is Meg Lassiat, and I'm the Director of Candidacy, Mentoring, and Conference Relations at the General Board of Higher Education and Ministry. I work with district committees and boards of ordained ministry through the candidacy and ordination process, as well as related to changes in conference relationships for clergy. The legislation that General Conference passed for the elimination of security of appointment for elders and associate members was contained in paragraphs 337 for elders and 321 for associate members. For elders, paragraph 337.1 from the 2008 discipline was deleted. This paragraph contained the phrase, "Elders in good standing shall be continued under appointment." The new 337.1 reads that ordained elders and persons who have been granted a license for pastoral ministry and who have been approved by the vote of the clergy members in full connection may be appointed. For associate members, the phrase "shall be granted the same security of appointment as provisional members and members in full connection" was deleted. The rest of that paragraph remains as is and retains the itinerancy and continuing appointment for associate members. After this legislation had passed, the General Conference elected to refer the question about the constitutionality of the elimination of security of appointment to the Judicial Council based on the following questions. Whether or not the elimination is a violation of the third restrictive rule in paragraph 19 and does away with the authority of the episcopacy, or if it is a violation of the fourth restrictive rule in paragraph 20, which takes away the clergy right of hearing, trial, or appeal. Additionally, a statement was issued in June asserting that security of appointment has not been removed because the guarantee still remains in paragraph 334, even though paragraph 337 was changed. Arguments are now being made for the validity of each interpretation around the retention or elimination of security of appointment. We will wait to hear the Judicial Council ruling before knowing the final decision and the scope of their ruling. Regardless of how the Judicial Council rules on the elimination of security of appointment, significant changes have been made to transitional leave and less than full-time appointment. First, let's look at the two reasons given in the new paragraph 337 for an elder not to receive an appointment. In the new paragraph 337.3, two reasons are given for an elder in good standing to not be appointed. And they are that a missional appointment is not available or that the elder is ineffective. If a missional appointment is not available, transitional leave, as outlined in the new paragraph 354, is the process the bishop and board should follow for that elder. If ineffectiveness is the reason the elder will not be appointed, the bishop and board should follow the process for administrative location outlined in paragraphs 334 and 361. So now let's look at the differences between transitional leave and administrative location. We'll begin with a discussion of transitional leave. The new transitional leave paragraph is 354 in the 2012 Book of Discipline. Transitional leave can be granted for 3 reasons. An elder or associate member is not appointed, a deacon is between appointments and is seeking an appointable position, a clergy person in extension ministry is in transition from that extension ministry to another appointment. The new paragraph 354 defines transitional leave as a status. It is not an appointment. Paragraph 354.1 reads, in order for the church to be missional in its focus and flexible in appointment making, associate, provisional, and members in full connection may move into the status of transitional leave for up to 24 months during a period of time that they are between appointments. Transitional leave may be applied to associate members and provisional or ordained deacons and elders and is limited to 24 months. Transitional leave may be at the request of the clergy person or at the request of the bishop. The request must come at least 90 days before the annual conference session and must be recommended by the bishop, cabinet, and board of ordained ministry. Here you see the required process, including a written request and the clergy and cabinet working together to develop a plan for future service. If the clergy person requests, that person has a right to interview with the Conference Relations Committee and bring an advocate to the interview. As with any other change in status, the recommendation will also come before the clergy session for final approval. Other contingencies to be aware of with transitional leave include the fact that transitional leave may be granted or terminated for deacons between the annual conference session, subject to approval at the following clergy session. And additionally, if there are active complaints or charges against a clergy person, transitional leave shall not be permitted until those complaints or charges have been resolved. The rest of the details related to transitional leave are in the new paragraph 354 in the 2012 discipline. When working with a clergy person who is ineffective, the procedure is different. Keep in mind that the process the discipline prescribes for ineffectiveness is administrative location, as outlined in paragraphs 334 and 361. Administrative location is a permanent status, which means that someone can continue in that status for the duration of their relationship with the annual conference. And it is used in cases where a clergy has been determined to be ineffective in the practice of ministry. A person on administrative location is still ordained, but is no longer a clergy member of the annual conference. Their ministerial service is limited to the church where they hold their charge conference membership and has restrictions for permission in order to perform ministerial duties. Additionally, someone who is on administrative location cannot be appointed to serve on an ad interim or temporary basis between annual conference sessions. Initially, when moving toward putting someone on administrative location, the bishop works with the clergy to identify concerns, develop a plan to address those concerns, and then evaluate whether or not the plan for development has worked and if the clergy will be effective in the future. If, after these initial steps are completed, the bishop determines that the clergy person cannot be effective, the recommendation for administrative location is forwarded to the chair of the Board of Ordained Ministry, and the administrative fair process for administrative location begins. The new paragraph 361.2 outlines the process for placing a clergy person on administrative location. Once the bishop makes a recommendation for administrative location to the board refers it to the Conference Relations Committee, who will hold a fair process hearing, according to the provisions of paragraph 363. After the hearing, the Conference Relations Committee makes a recommendation to the board, who will then confirm or deny that recommendation. The administrative process is discussed in more detail in the webinar on administrative process. Additionally, there will be a workshop at the BOM quadrennial training in October that will work through the details of a fair process hearing. The final change related to appointments is the change to the process for elders to receive an appointment to less than full-time service. The 2012 Book of Discipline allows an elder to be appointed to less than full-time service at the request of the bishop and cabinet. In the past, the request for less than full-time could only be initiated by the elder. This is a significant change. Keep in mind that the request or notification for this appointment status must happen at least 90 days before the annual conference session, and someone appointed to less than full-time service retains all membership rights in the annual conference. Also remember the required percentage needed for approval from the clergy session. Another piece of legislation to be aware of when considering less than full-time appointment regards the pension program. The 2012 Book of Discipline allows annual conferences to decide if those receiving less than full-time appointments will qualify to receive pension benefits from the annual conference. So if you're considering whether or not to place someone in less than full-time service, you may also be making a decision about the pension they will or will not receive, depending on your annual conference's policy. As boards and cabinets work with clergy in making these appointments, this is a critical issue for you to consider. Thank you for your participation in this session. If you have additional questions, my contact information is listed here. Thank you for your work and your ministry on behalf of the United Methodist Church.